Thank you so much, everyone, for joining us today for this webinar on the litigation to protect abortion access in Louisiana during the COVID-19 pandemic. My name is Louisa. For those of you who don't know me, I am the manager of state advocacy initiatives at the Center for Reproductive Rights. And we're thrilled to partner with Lift Louisiana on this webinar. And I just want to go through a few quick housekeeping items before we get started. The first is this webinar is closed to the press, so if you are a reporter, please disconnect now. We also ask that everyone please keep your lines muted for the duration of the presentation so we can all hear the speakers. We will do Q&A at the end. And if you have a question that comes up during any of the presentations, please feel free to just use the chat box to send that question to the hosts of the webinar, and we'll make sure that we get to everything at the end. And that way we won't have background noise during the presentations. Today, we're going to hear from a number of amazing people. We're going to start off with two of the attorneys who brought the litigation to keep Louisiana's clinics open during this pandemic, Jenny Ma and Ellie Schilling. We're also going to hear from Kathleen Pittman, the administrator of Hope Medical Group for Women in Shreveport. And then we'll hear from Michelle Ehrenberg, the executive director of Lift Louisiana, about ongoing advocacy efforts. And then we'll go into Q&A. So without any further ado, I'm just going to hand it right over to Jenny to get us started.
Thanks so much, Louisa, and thank you all for joining us on this webinar. We really appreciate you taking the time. And as Louisa mentioned, this is largely about the abortion access and keeping Louisiana's clinics open in the time of COVID-19. And I just really want to shout out to all of you who have persevered, many of you who are on this webinar, and also to Ellie, who co-counseled with us in this litigation. And she'll be kind of giving you more of the specific information behind what we did in Louisiana and what our claims were, and also how what the status is currently. I'm going to touch a little bit upon the backstory to all of this and how we got here. So I'm going to present a couple of things. The national picture of what kind of happened when those of us who were lucky to work from home began to do so, and what we started seeing from the anti-states. What we were doing in Louisiana before we even filed, and just kind of tracking what was going on, working with Hope and Delta and Women's in kind of keeping an ear to the ground about what was happening, as well as some of you who are on this call. And then finally, just before we kind of go into the specifics of the lawsuit, I'm just going to give a general picture of where things stand with the other litigations that the center has, including the Supreme Court case. So as many of you know, in March, which seems like 100 years ago now, on March 4th, we had oral argument in June Medical Services versus Russo. Defendant keeps changing. It was Guy before Russo, and now Courtney Phillips is the head of LDH. So, you know, I personally slept outside that day, and I know it was a big day for many of you on this call, and certainly a lot of prep, and we were just super excited, right? We were finally, all of that work was going to culminate into a presentation before the court. And just being there, it was very cool, for lack of a better word. It felt like a stage, and everyone was in their robes, and the reporters were on one side, and there was a lot of pomp and circumstance. And I thought that the oral argument went very well for our side. I think it's not any surprise that since the law was struck down as unconstitutional, the admitting privileges law just 4 years ago, that we had the better of the legal argument. So we kind of left there being like, okay, like, what we do now is just wait for the decision to come down. We really did not expect to be suing Louisiana so quickly thereafter, but that's kind of what happened. So after we left, you know, COVID-19, the coronavirus kept circling around. Louisiana became a hotspot, and all across the nation, there were various kinds of orders through the governor, so executive orders through the governor's offices, or health department notices like the one that LDH had put out, saying, you know, they were differently worded, but it was some form of only essential healthcare can move forward. Anything non-essential, non-timely, elective, kind of these keywords, right? No, none of the anti-states specifically said abortion in their orders and notices. Some states actually went on the affirmative, I don't know, see the kind of maybe thinking that this might happen. So a slate of states actually said reproductive health care and pregnancy-related care is absolutely essential. And the first thing we saw, I think, way back in the early portions of March, that first or second week of March, was all of these notices starting to issue. And then that Saturday, the governor of Ohio specifically said, hey, you know what? I'm going to put out a public statement saying that abortion care is not timely and non-essential. Now, the center is a national group, so we kind of jumped, kind of knowing that this might happen because your spidey sense kind of tingles whenever abortion care is brought up, right? And we talked with our partners at the ACLU, at Planned Parenthood, and the Lawyering Project, and we were like, look, this might be kind of a thing that's going to happen all across the board. And I'll share with you guys that Louisiana was very much on our radar, no surprise. I think, you know, we thought that it was going to be, as it has been, a market leader in putting out abortion restrictions, and particularly seizing on this COVID-19 opportunity to ban abortion care during this pandemic. And so we were very cognizant. Ellie and I were like starting to share texts like starting that weekend. And then what we saw was certain states moving forward and ahead. So Texas, obviously, I'm sure many of you have heard, that case went briefing on all three levels of the court. And ultimately, as this slide shows, we and our partner orgs ended up filing litigations in 9 states. So I'm just going to go through these because I think it's really important for you all, when you speak to folks, to know where things stand. Obviously, these kind of came in different waves, but you have that list there. So Alabama, Arkansas, Ohio, Louisiana, Ohio, Oklahoma, Tennessee, Texas, and West Virginia. And I just want to be clear about a couple of things. I know you all are very cognizant of these issues, but right. Number one, these are kind of, as I mentioned, the market leaders on abortion restrictions. So it's not anything new, right? There are states out there who said, of course, abortion care is time-sensitive, essential health care. And these are the same states that constantly put out restrictions, that have tried and tried many gestational bans and other ways to make sure that access is decimated, or that clinics can no longer operate in the circumstances that they find themselves. So it's no surprise, even though, I mean, truthfully, the optimistic side of me was very surprised that this had actually happened, that these states kind of went first. And I want to also emphasize, not only do you get to hear about like the case being filed, and again, going more into detail with Ellie in Louisiana, but we were also monitoring so many other states that are not on this list, right? So these are emergency lawsuits, because you have to like basically go into court right away and say, okay, we need this to stop. We need the state to get restrained from implementing this law as applied to abortion care. So for every state that you see on this list, there's another whole group of states that everyone had been working on. So it was really tough. Not only are we all dealing with our mental health and physical health during this crisis, but seeing these states kind of activate in this way was truly gross. And in my view, pretty damning, and really kind of exposed what they're really after, if we haven't known already. So I show this list just to say that every single district court ruled in our favor, or there was some agreement that was reached. So Iowa, immediately after that lawsuit was filed by Planned Parenthood, they reached a settlement agreement with the state. But every single district court that weighed in ruled for a temporary restraining order and an injunction against the law, meaning that the law cannot go into effect, which is really wonderful that every court that saw our evidence ruled in our favor, because the evidence is in our court again, right? The American Medical Association, who doesn't really opine until recently on abortion care, came out with a very strong statement saying abortion care is absolutely time essential. This is not the time for politicians to be playing around with healthcare. And so that's really fantastic. ACOG, which is the American College of Obstetricians and Gynecologists, along with 17 other leading medical health and health organizations, also weighed in and saying, this is what we know, which is abortion is essential health care, and this is not what should be happening right now. So we had the evidence on our side. We had, the knowledge that all of these states have been just kind of doing the same thing that they've always done. And abortion care is now in all of these states. I do want to caveat with a couple of things. Unfortunately, Arkansas right now is medication only. There, as I mentioned, a district court did give us the restraining order, but then the state went immediately to this emergency appeal, which is called a mandamus, which I won't bore you with the gory legal details of that, but many states have tried this, and so this was tried almost universally and successful only in the Fifth Circuit, which is unfortunately where Louisiana is, which is no surprise. So when Texas's lawsuit kind of made it all up the ranks, the Fifth Circuit decided that this was okay. And they were so craven, in fact, that at one point they stopped medication abortions for just an hour. And I really want to emphasize that, because that our clients had patients who were in the waiting room waiting, and they actually got pulled because that's what the Fifth Circuit did in their offices in New Orleans. So abortion care is available throughout, except for Arkansas, where right now only medication abortions are available while the pendency of that lawsuit continues. And then also in West Virginia right now, that lawsuit is kind of new and continuing. And everywhere else at the current moment, we are resuming services, and they are hopefully, like the COVID curve, somewhat abating. I'm hoping that the states have kind of lost their zeal right now in kind of advancing these types of suits. So that is what the picture looks like. As I mentioned, Ellie's going to go into further detail about Louisiana, but Louisiana was on our immediate okay, we need to be really watchful of what's happening here. And we've been obviously in close contact with our client, Hope, who was a plaintiff in our lawsuit, but also with the other two clinics, Delta and Women's, to make sure that our efforts, both in complying with the notice as well as kind of any actions, were really well coordinated. So I'll leave that here as to the national landscape picture, cognizant of time as well, and then also just briefly touch upon the other litigations in Louisiana, which some of you have heard about, but I just want to kind of touch upon what else is happening out there. So number one, the SCOTUS case. So as I said, March 4th, there was argument. We are waiting for a decision. As those of you who closely watch the court know, they've actually started picking up doing remote hearings. There has been lots of technical difficulties. If you want to see cute older justices try to figure out the mute buttons and stuff, it's been kind of interesting to hear. Today they actually heard about the contraception rule, and just arguments are going to continue. We don't know what the virus's kind of impact is on the drafting of any opinion. So in terms of when we expect a decision in June Medical, I will share with you all that there will be lots more for Lift Louisiana and the coalition as we kind of develop different messagings and coalition messagings, and probably more of these types of conversations to be had closer to decision day, because we don't know, right? We have no idea when it'll come out. They are issuing decisions. So the earliest, which I would not, if we were betting, put money down on tomorrow, is a decision day. I don't think that our decision will come out tomorrow, but that's the earliest it can come out, and then we can go as far as to the end of June. So anytime between now and then, we'll probably see a decision. I think that there's a lot of firecracker decisions out there, including the LGBTQ Title VII case, which was argued in October, so so much longer ago, that we will probably see beforehand. I mean, that's my personal opinion, but I don't know how the justices obviously will rule. So that's one to look out for. We also have two other litigations super quickly. One is all of the laws that were put forth by the legislature in 2016. So that was a banner year, as all of these years kind of tend to be for the Louisiana legislature, and they passed a multitude of laws, all of which were challenged. And currently, because of an agreement we reached with the state, those are not being enforced. And I'll just mention a couple of the most egregious ones, which is fetal burial, raising the 24-hour waiting period to 72 hours, and then also additional requirements, which really are terrible, as to second trimester abortion. So basically a D&E ban. And the final one is an affirmative case where we are challenging the licensing, the constitutionality of the separate additional licensing of abortion facilities. And I'll just kind of leave it there. That gives you a wide swath of how we found ourselves here. And then I'll turn it over to Ellie for the specifics of what went on in Louisiana.
Thank you, guys. I'm now unmuted. Okay, Louise taking care of it. So as Jenny said, then obviously from the beginning, then there was a lot of concern that Louisiana would be one of the states that would decide to take advantage of the pandemic. But they didn't really do anything to begin with. The clinics were all still operating, and we were very confident that they were all in compliance with the terms of the notice. So the way this started actually was us trying to avoid litigation, trying to have discussions with the state, formally, informally, on the record, off the record, all sorts of different approaches to try to get the state to engage and say, yes, you guys are right, everybody's in compliance, let's not get in a big fight here. Unfortunately, then the state engaged very little in those negotiations. It was particularly disconcerting that very early on, then the Department of Health basically punted the issue over to the Attorney General's office. And those of you, at least in Louisiana, know that Jeff Landry, our Attorney General, is very, very aggressive in his attempts to restrict abortion access. And he is the one who is defending all of the laws and lawsuits that Jenny just described in Louisiana. So things kind of continued along those lines for a little while. Everybody was operating, and we were hopeful that the state wouldn't do anything crazy. And then, of course, the Attorney General's office started making all these kinds of rumblings and press statements and press releases saying that the clinics are violating the law and that they should be shut down. In his initial press release, then he called on the Department of Health to enforce the law and close the clinics, which, just to sort of put a finer point on that in terms of how ridiculous that is, then the AG's office was taking the position that LGH was their client, and then they issue a press release, telling their client what action they think they should take. I mean, I have a lot of clients. I certainly have never tried to get them to do anything by issuing a press release. So then it just kind of started escalating from there, largely driven and almost really solely driven from the Attorney General's office, which then culminated in him sending in his own people from the Attorney General's office to search the clinics, asking staff questions, insisting on being able to review patient records. And he has no jurisdiction and no authority to do that. To put a finer point on that, those of you who are familiar with the Hyde Amendment will kind of get a kick out of that. The people that he sent in were from the Medicaid fraud unit. And as we all know, based on the Hyde Amendment and state law, then it's basically impossible to get Medicaid to cover abortion services. So as I said to Jenny at the time, it's really not that different than if the Medicaid fraud unit showed up at my house and started asking me to look at my, personal records and private documents. I would be, tell them, I'm not a Medicaid recipient. I'm not a healthcare services provider, so I don't treat Medicaid patients. And then if the fraud unit was like, yeah, we don't think that's really important, we'd still like to come in your house and ask you some questions and get you to show us your documents. So when that happened, and particularly when they were demanding patient records, then we realized that we could not wait any longer and we absolutely needed to file suit. So we did very quickly, as Jenny said, similar to other states, asking for an injunction. And there are 3 claims in the lawsuit. One is a substantive due process claim. That's the undue burden claim, the sort of typical claim that we see in this type of litigation. The other one is an equal protection claim, which is also pretty typical in this type of litigation, basically saying that, you know, the government is treating abortion providers differently than they're treating similarly situated healthcare providers. And then the third claim was a Fourth Amendment claim. So the Fourth Amendment is the part of the Constitution that protects you from warrantless searches and seizures, for unreasonable searches and seizures. And there's been some Fourth Amendment litigation in this context, as Jenny was saying about the TRAP case. There's a Fourth Amendment claim in that case, but it's really very different because that the government ostensibly has authority there to, based on their statutory scheme, to search the clinics. It's just a matter of whether that is in conflict with the Constitution. Here, then, the Attorney General's office could literally never point, neither the Department of Health, nobody could point to anything that would give him the authority to send law enforcement without a court order, without a warrant, in to search the clinics. And the only thing they ever said is just this cockamamie theory of that, you know, he had convened a COVID-19 task force and that the COVID-19 task force was working with the Department of Health. But again, there was no authority to do that. So those were our claims. And from the beginning, after we filed suit, it was interesting because the state handled this case differently than they handled most of these cases, meaning that there did not seem to be a huge willingness on their part to litigate. There did not seem to be a desire to be overly aggressive as they usually are. My firm belief is that's because of the Fourth Amendment claim and because of the actions that the Attorney General took. I think he knew he was out of his lane and that potentially it was going to be very embarrassing for him. And the last thing that he wants is a federal court saying that he doesn't have authority to do X, Y, and Z, because those of you who are in Louisiana know that it's not just in the context of abortion clinics, in a variety of contexts. Then the Attorney General's office, Jeff Landry, takes actions that he has questionable at best authority and or jurisdiction to do. So shortly after we filed suit, then the state issued the new Department of Health notice. I'm sure many of you have read about it in the paper, which for healthcare services broadly, then it creates far more ability for time-sensitive care and not just for sort of emergency care. So they have allowed a lot of different healthcare services to resume. The PPE situation and the hospital capacity situation had improved by then. I do think, though, that they issued this notice partially because of our lawsuit. The notice is good for people in Louisiana in general. You know, it's providing people with more access to healthcare during this crisis. And so they would have done it at some point. But credit to John Bell's administration that whereas a lot of these other states, as Jenny was saying, just like continue to double down and continue to insist that there was an ongoing crisis in terms of PPE or an ongoing crisis in terms of hospitalization, then they took a different approach and said, actually, you know what, we're going to start resuming a lot of healthcare services, including abortion services. So basically then we were able to resolve the lawsuit. We were able to, you know, say to the state, okay, how about everybody just move on? And you guys agree that abortion care is covered by the new notice. And we agree that the terms of the notice apply to us the same, you know, apply to abortion clinics the same as they apply to other healthcare facilities. And let's move on. So we have dismissed the suit without prejudice, which is also important because that means that if they do something else crazy under the new notice or just something relatedly, to this whole COVID-19 and the old notice, the new notice, then we can file suit again. We haven't lost that right. So that's kind of like start to finish the timeline and status. I just want to point out 3 things that I think are sort of like important takeaways here to remember in general. One is that, it's important to deploy all of the different strategies at your disposal, which we did here. And this type of litigation often, and these types of conflicts often do not, they don't engender that type of strategizing. So in other words, I mean, I have a commercial litigation practice. Like, you would always try to negotiate, file suit, and settle. Those are the 3 things at your disposal that you can do. And we did all of those here. So that's something that's important to remember, is that, we should not just assume that one or all of those things are off the table, and do what we can with all of those strategies. But the second thing being that if it becomes clear that negotiations are not going to work, then we should be comfortable being proactive in bringing litigation, which is what we did here. We didn't wait for the state to go shut the clinics down, or to issue a cease and desist letter. It was very clear that they were ratcheting things up, and that the situation was getting worse, and that was probably where it was going to end. And so we were proactive and went ahead and sued them so that it didn't happen, so that the clinics wouldn't have to close even for a short period of time. And the third thing I think is to remember how suits like this have an impact on, government accountability and government overreach, basically. I mean, these types of suits, there's a measure of that always whenever you sue the government, right? And those of you who know Lift Louisiana know that, like, that's one of our sort of core missions and values is holding the government accountable, and not only in the context of abortion access, in a lot of different contexts. Many of you also will know, who follow the legislative session, that often is difficult. We're telling them that, I'm telling them that every year, you're going to get sued, you're going to lose, and they don't care. There isn't that measure of government accountability because the legislature is removed from that process more. But here with the Attorney General's office, then, there was a lot of government abuse and overreach with what he was doing. And I think that, this suit, was a strong message to him that he needed to back down, or it was going to be embarrassing, and or there was going to be a federal court order against him. So, that's just something else that lawsuits like this can do. And we'll see, of course, how the AG's office reacts going forward. But I do think that it will act as some check on, jurisdictionless, unauthorized actions on his part. Because, as I said before, people in Louisiana know that he has had a tendency to act like a sheriff in the Old West, or there are no rules. So those are the 3 main things that I think are important to keep in mind going forward. And I'm happy to answer any questions when we're at the question part.
Thank you so much, Ellie. And if folks have questions now, please feel free to keep putting them in to the chat box, and we'll read them back out for all the speakers at the end. And now I'll turn it over to Kathleen Pittman from Hope Medical Group for Women in Shreveport.
Hello, everybody. When all of this first started and the state issued its mandate, it goes without saying, without our legal eagles, we couldn't have even attempted to move on. So allowing them to worry about the legal end of things, leaving us with just the practical day-to-day aspects of running the clinic and keeping the doors open. The first thing we had to do was get over ourselves and understand that we can't be all things to all people all the time. Immediately, biggest concern, first and foremost, would we have the staff? I mean, we had to ask the staff, are we in or are we out? And certainly some of our staff with pre-existing conditions, we had to be concerned. We did not want anybody doing anything that would leave them uncomfortable or even at more risk. So I think we started with about 20 hourly employees right off the bat. We had 4 that we removed from the schedule for either pre-existing conditions or concern that they may have already been exposed. With that being said, this last week, 2 of those did return. Everything worked out fine for them. We literally walked through the clinic, involved nurses, counselors, everybody walked through the clinic with the tape measure, measuring what we needed to do for social distancing. We understood at the get-go that we would have to slow things down, and if there were greater wait times between patients for the physicians, they would have to get over themselves as well, which is easy for me to say, not always easy to put in practice, but they've been great nevertheless. One of the first things we had to do was stop allowing support persons to come in with patients. Drivers check in, then drivers must go. That hurt my heart because that's always been a big part of what we are. Giving up on the tea and cookies that we are so renowned for. If we have patients in masks, we can't have them sit there sipping tea and snacking on cookies in the recovery area. Little things like that you think might not count for much. A couple of things we did not anticipate, and that was the absolute snarkiness and tackiness of the AG's office and some of our other political figures. Everything on social media immediately started creating more of adversarial type situation for us within our community, actually. Phone calls ringing off the wall. We would go from one patient crying, trying to get in to be seen, with staff trying to hold it together because there are times we have to say no. And then immediately after that call, we had got one from an anti that was making some really ugly comments. One thing we did not anticipate was the roller coaster. Really made our phones just ring off the wall. We literally had to bring in additional staff during this time just to man the phones. I think the second Thursday, all this was in effect. Thursday's normally not a really busy phone day for us, but on that day alone, we made like 90 appointments. And that's appointments. That's just not just phone calls. We found ourselves for the first time ever having to schedule almost a month out for that first visit. In Louisiana, for those of you who don't know, we do have a 24-hour waiting period, which means 2 visits to the clinic. And where we really struggled was getting patients in a timely fashion for that very first visit. A lot of women were about to be too far gestationally or too far for the pill. So, it was a constant onslaught of, let me put you on my waiting list. The minute I get an opening, we'll contact you. And we were really good about that, following up. From the very beginning of all of this, I think on the first couple of days, we weren't trying to mask everybody that walked into the building. Ultimately, we did that. Anything from regular masks, surgical masks, to bandanas tied around to cover the mouth and nose. And as things have evolved, it's actually gotten quite to be the fashion accessory. As things have moved along, we see a lot of cute stuff coming through that we threaten to steal from patients these days. Patients have been stressed beyond belief when they first make that call and find out it's going to be 3 weeks before they can even get in. They're just terrified. What happens between now and that appointment day? Will the state come shut us down? They're doing, look what's happening in Texas. We saw, under normal circumstances, we see about, I think it's 22% of our patients come from East Texas, and we immediately saw a jump over 32% to over 33%. And when you have a limited number of days that you can see patients, that makes a huge difference for us. We're open 6 days a week. All 6 days, we traditionally offer consults. We had to rethink that because there was not space in the facility for that. So we reimagined everything. 3 days a week, we do consults. The other 3 days a week, we do procedures. We are still currently right about a week and almost 2 weeks out for that initial appointment, unless it's an absolute emergency. Texas having their doors open again has made a huge difference for us. It has given us a little breathing room, even though we would try to put patients off in order to see those that had to be seen first. Also trying to do what the state was asking, postpone any you can. The crazy part there is if you postpone anybody, that just means more people you have to see a month from now, which is automatically going to put some people out of the picture. They're not going to be able to be seen because we can only spread ourselves so thin. So trying to justify having our patients having such an incredibly busy April with a smaller than usual staff, brought in a couple of former employees that are now permanent again because they miss us. So that's been lovely, I will tell you that. I was did want to mention the patients being so stressed really creates this an absolute craziness for the staff, because we are traditionally or try to be kind. And when we're getting a lot of pushback and a lot of anger coming from patients, even though we know why, we know they're frightened, we know they're desperate. Again, it's been kind of amazing. It's like some of our meanest patients, I guess, for lack of better terms, we find that after the procedure is done and they're ready to walk out the door, they're the ones that are going to stop at the front desk and apologize and thank us all over again. It's like, okay, their crisis is over and now they can be the person that they actually are. We normally don't see cruel people. We've had to suck up a lot. I mean, that's just the way it is. The distancing, has been difficult for us because we are normally quite the huggers around here. I sit in my office. It's not unusual for patients to drop by and want to hug my neck and tell me to thank the staff or whatever. And I'm like, oh no, 6 feet away, please stand back, as much as possible anyway. So it's not been easy. It's been well worth it. I can't believe it's been this many weeks already, and we've actually survived. So hopefully we'll never have to go through this again. I will tell you, we made some changes in our protocols that we will probably maintain. We've learned a lot. So it's not just been everything bad. There have been some very positives that we've picked up from all this. And that's what I have to say.
Thank you so much, Kathleen. So we're going to change the order of things up a little bit just because we got a bit of a late start. So we are going to move ahead to the Q&A quickly now and then circle back for a quick advocacy updates from Michelle at the end, just in case anyone has to hop off a little bit early. We want to make sure that you're able to be here for the Q&A. So we've had a few questions come into the chat box, and please keep sending those our way. I will just start us off with a question that I'm gonna direct to Jenny, but Ellie, other speakers with thoughts on this, feel free to jump in. Can you talk about the potential impact of the SCOTUS non-unanimous jury's case on Roe v. Wade? Should we be concerned about that in the long term?
Sure. So this case is a case called RAMOS, and it's a Louisiana unanimous jury's case along with Washington State. Funny enough, the argument was brought by Liz Murrell, who is the Solicitor General, who argued the June medical case for Louisiana as well, and who we were kind of consistently talking throughout this COVID-19 litigation. If you read that decision, it's very bizarre. So yes, you need a unanimous jury in Louisiana, so yay on the outcome. But it's like a choose your own adventure. there are justices that you would never think, it's not a 5-4 decision. It's like, you know, how is it that one of the most liberal judges is siding with these two very conservative judges, and what is it all about? And I think, separate and aside from the attack ultimately on Roe v. Wade, I think there was a lot of signals in that case by the justices on our June medical case. So obviously you have folks like Justice Kavanaugh who said, you know, you don't really have to adhere to precedent. And I don't want to make everything about abortion, but as this kind of crisis showed us, that many things are about abortion. And I think this case definitely was signaling that, hey, maybe one day you don't have to follow precedent. You don't have to necessarily have Roe v. Wade be the law of the land, or you don't have to have Holm and Health, the decision about admitting privileges 4 years ago from Texas's law, applied to Louisiana. So we had, like, obviously Kavanaugh's view. And then what I think I just want to point out, which was super interesting, is that Justice Kagan sided with Justice Alito and Chief Justice Roberts. So 2 conservative justices and 1 kind of liberal-leaning justice sided with them on one particular aspect of that decision, which was, even if you do not agree with the underlying policy, you adhere to precedent. And so she got actually a lot of flack for that. There are articles out there about, like, what is Justice Kagan doing here? Like, why is she suddenly siding with these folks? And it really, I think, signaled, hey, Chief Justice Roberts, who is the probable tiebreaker in a potential 5-4 decision in June medical, you better stick to precedent. Even if you do not agree at the end of the day on the underlying law, you better stick to it. So I think immediately there were some signals about June medical there, and I think that the person who asked the question is right, that, like, it applies to a lot of precedent. Like, I think, you know, it's social cues saying, hey, you know, if certain justices on the court think that, like, you can kind of break away from precedent. So I think that that's kind of the underlying import and how it applies to abortion in that case.
Thank you, Jenny. Okay, so we've got a couple more questions. Let's go this one. We have a question. In Lafayette, we had a notable case of a crisis pregnancy center conspicuously posting photos of its staff using PPE to do sonograms after the closure of non-emergency medical procedures. Have these centers been closed or restricted in states that have imposed COVID shutdown restrictions on abortion clinics? I can actually speak a little bit to this one, and then folks in Louisiana, feel free to chime in. Unfortunately, no, these orders certainly, and these efforts have not been applied uniformly. We really, as in the states that we've seen use the pretext of this crisis as a means to restrict access to abortion by trying to force clinics to shut, you know, already that's a deviation from what should be the standard of applying something like an order that's supposed to protect the public health uniformly in an evidence-based way that will actually keep people safe and healthy, which would mean not using it to block essential time-sensitive healthcare like abortion care. But as states are deviating from that, they're also not at all, you know, applying this kind of restriction uniformly to providers of care that is not essential or not really very medical in nature, as is usually the case with crisis pregnancy centers that usually most often don't have medical personnel on staff and are really not doling out scientifically sound or medically accurate information or services. So unfortunately, rather than seeing this, you know, sort of cut both ways and put a pause to some of that misinformation and you know, shenanigans of crisis pregnancy centers. We've seen states like Texas go on Facebook Live to do a, you know, live stream with an anti-abortion group and talk about how, you know, CPCs are very essential, and then segue into their efforts to restrict abortion care. So that's unfortunately what we've been seeing. And if other folks have anything to add, please go ahead.
I would just say, this is Michelle from Louisiana. So the order to, you know, limit non-essential healthcare services was applied to licensed healthcare facilities, and the crisis pregnancy centers are not licensed facilities in Louisiana. They're not regulated in any way whatsoever, which is a huge problem. And so just sort of by the letter of the law of the directive by LDH, it would not have applied to them.
Thank you. Yeah, that's definitely important too, as it just underscores the nature of, you know, sort of what CPCs are up to versus, you know, the meddling in the provision of really essential medical care. We have one more question that I'm gonna pass along to Jenny and Ellie. How did you approach the initial contact with the state after the first order that sort of started all of this? Can you talk about what that looked like, and you know, the beginning of this process a little bit more?
Sure.
Sorry, go ahead, Jenny.
Go ahead.
I was just going to say, yeah, I mean, you know, as I sort of alluded to before, then, I mean, we approached it as you would anytime that like a conflict kind of starts to seem like it might brew up with somebody who, you know, you have some sort of a business partnership with. So generally speaking, like in the litigation context, you then approach the other side and say, hey, you know, this is, we just saw this order. This is what happened here. We just saw this order. We think that this is what it means. Do you guys agree that this is what it means, so that we don't have to get into litigation about it? So that basically just was, you know, reaching out to the Department of Health and government officials to try to resolve things on the front end, like you would in any kind of situation where you thought a dispute might arise that didn't need to arise. Jenny, do you want to add to that?
Yeah, I'll just add, like, the notice itself, right? Like I said, doesn't have the word abortion in it. So on its face, there's nothing really problematic, right? It's the way that it was applied to abortion care. And I think this kind of ties into that, the other question, which is 100% of one type of healthcare was visited, right? All 3 of the abortion facilities in Louisiana were visited, and that discretion was supposed to be, whether it's time sensitive and essential, on the providers. Instead, it was punted to government officials and all the folks that Ellie kind of spoke about earlier. So from our perspective, when we saw this, we were like, okay, well, of course, we're going to get together with our client and talk about all the things that they've already done, which Kathleen talked about, but also like give our best recommendation on what the next steps look like. We revised policies so many times. I mean, Kathleen can attest to, we were like, okay, like this is how it's responsive to this notice and how now it's changed. And so we did everything possible, like Ellie said, in a strange way, which is normally not both the way that the defendants reacted here, but also the way we would act, which is we tried every method not to sue here. And it really was, at the end of the day, our hand kind of got pushed by these like increasingly threatening actions to a point where we were like, look, if we don't act now, then abortion care really will be completely eradicated, because that's where we're moving towards. I mean, they're publicly saying it out there. And then otherwise, I mean, our clients are being harassed here. Like, we did not want any negative consequences to come to Hope for all the things, by the way, that they had been doing, which you heard about today.
Thank you. All right, so I'm seeing a couple more questions come in. Just give me one moment to read through some of these and we will keep going. So this is sort of more, I think, again, for Jenny and Ellie and Michelle, what other things are you seeing that concern you about the AG's, you know, posture regarding patient confidentiality? This person mentioned or asks about sort of the medical privacy aspects, and how the patient records of patients who are going to Louisiana's abortion clinics have been sort of involved in these situations, and also alludes to some, you know, similar issues regarding sort of efforts to respond to sort of COVID as it relates to voting in Louisiana, other contexts, including seeking abortion care. So I think this person is wondering, you know, what what else are you seeing that ties into this sort of regard or lack of regard for patient privacy, personal privacy, and how that is interacting with the pandemic?
So I can speak to that, the first part in terms of patient privacy and the Attorney General's office in terms of some things that we have seen in recent years and that is pending right now, in theory at least, pending legislation. And basically it's just that a lot of maneuvering to try to give the Attorney General's office more authority to be able to access patient medical records, specifically from abortion clinics. So there is legislation that was passed last session that purports to give the AG's office more authority to be able to access patient medical records. That's the same bill that also then requires clinics in a very burdensome way that also potentially undermines patient confidentiality to maintain records for a very long time. This session, then there's a bill that's proposed by Beth Mizell that specifies that certain types of patient records will be given to the AG's office, specifically abortion records related to minors who are 13 and under. Those records already go to the Department of Health. The records having to do, they are non-patient identifying for the most part, already go to the Department of Health for every single abortion, but this would mandate that records regarding abortions of minors, 13 and younger, would also be sent to the sent to the AG's office. And the bill is not clear that it wouldn't be patient identifying. And quite frankly, why would it be? What are they going to do with it if it isn't patient identifying? Because, their whole plan and theory is that they want to explore whether mandatory reporting was properly done. And, in theory, they say they want to, prosecute then any potential crimes, but this would be given to them regardless of whether there was a potential crime. So there's a lot of stuff that they're up to, that they want to be able to go through patient records. It's not clear how a lot of that will end at this point, but keep Beth Mizell's bill on your radar. I don't know if Michelle or Jenny want to add anything else to that.
Well, we're almost at the hour, so I think I'm seeing not as many questions still coming in. Why don't we turn it over to Michelle to sort of wrap it up by, this is a great segue to advocacy efforts that are currently taking place in Louisiana as the legislature has returned to its session, and all of this is still going on. If folks have other questions that come up, feel free to keep using the chat box or reach out to us after the webinar, and we're always happy to speak to anything that's on your mind. And so Michelle, take it away.
Okay, great. I will try to be quick. So yeah, as Louisa mentioned, the Louisiana legislature went back into session this week, and we saw before the session adjourned a few weeks ago that there were a couple of abortion-related bills that had been introduced. We don't know at this point how many of those will be moving forward during the session, but we are keeping an eye on them. So I just kind of want to go over a couple of them very briefly, and then we can follow up with the specific bills for folks who joined the webinar. So one is, most of them are actually by Senator Beth Mizell. One of them requires additional training and reporting on how training is conducted on human trafficking awareness and prevention, and carves out more specific things that abortion clinic workers would have to do to be in compliance with the reporting and training, for human trafficking. And so, I think that we're following this one because, again, it sort of just targets abortion clinics for having to do extra things, and that, other service providers that are also required to have these kinds of training aren't really required to do in terms of, you know, timeline and reporting. And so just, again, it's, you know, treating abortion clinics as exceptional and in need of more oversight when we know that that's not actually necessary. The other one was what Ellie mentioned earlier, that just has the Louisiana Department of Health report a lot more information to the Attorney General's office and to the Department of Children and Family Services, including, you know, copies of all reports of abortions where someone is under the age of 13, or all reports from hospitals of people that, you know, come to the hospitals with some sort of medical complication from having an abortion. And then another one that was filed late that actually did get a hearing this week is not abortion specific, but it has implications and is related to some of Meisel's other policy proposals. And this bill would, you know, require that mandatory reporters of child abuse must report all instances in which someone 13 and under is pregnant. And so it assumes that pregnancy for someone of that age group indicates that some sort of abuse or criminal sexual act has occurred. And, you know, I mean, we know that in Louisiana that we have high rates of teen pregnancy, and, you know, there are 13-year-olds that are having consensual sex, and although it's not desirable, it's not criminal activity. And so our concern here is that it would subject these young people and, you know, their families to potentially criminal investigations, which could dissuade them from, you know, from seeking much needed health care, especially for a young person. Carrying a pregnancy can be quite high risk. So those are the pieces of legislation related to abortion or, you know, pregnancy that we are keeping an eye on. In addition, we are, you know, trying to keep track of things that would provide more paid leave to people, and also would expand access to midwives and doulas, and make those kinds of healthcare services for pregnant people more available. So that's what's happening in the legislature. And then in addition to that, obviously we are working very closely with the center to sort of prepare, you know, a plan of action for decision day in the June medical case. And so we will be getting information out to all of you and our networks as quickly as possible on decision day to help you understand what that decision is, and, you know, and how we as a community need to be responding to that moving forward. And then the last thing that I'll mention is that in November, on the November 3rd, 2nd ballot, there is an anti-abortion constitutional amendment which would enshrine basically, you know, a statement in the Louisiana Constitution that could effectively ban abortions and any public funding for abortion. And so we are working with a lot of other partners with the Louisiana Coalition for Reproductive Freedom to form a new coalition specifically to work to oppose that amendment. And so look for much more information from us about activities. We will be, you know, starting to recruit volunteers and really trying to get people much more engaged in spreading the word about how dangerous that constitutional amendment could be for abortion access in the state. So that's it.
Thank you, Michelle. I think since we've gone 5 minutes over, we will wrap things up here. But thank you so much to all of our speakers, Jenny, Ellie, Kathleen, and Michelle, for all of the information that you shared. If folks have any further questions, please don't hesitate to reach out to us. We're always happy to answer anything that you might be curious about. And thank you all for your attention, for joining us today, and for your really thoughtful questions. It's been a pleasure chatting with you, and hope you have a good rest of the week.
Thanks, everybody.
Bye, everyone. Thank you.
Bye.
Bye.